Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, I'm Matthew Hall, and I'm with Olivier Guersent, Director-General of the Directorate-General for Competition of the European Commission, or DG Comp. DG Comp is based in Brussels, is responsible for the Commission's policies and enforcement of competition and antitrust law. As such, it is the lead competition regulator in the EU. The Director-General is the most senior permanent staff member within DG Comp, reporting directly to the Commissioner for Competition, Commissioner Ribera. Director-General, welcome to your fourth consecutive and I understand final appearance on Our Curious Amalgam from the Antitrust Spring Meeting.
Thank you, Matthew. Good afternoon and good afternoon, everybody.
Well, it's good to see you once again here in, I think, the same room that we've enjoyed speaking with you in the last few years. Commissioner Ribera, pursuant to her mandate from President von der Leyen and also following the Draghi report on EU competitiveness, has said, and I quote, "It is clear that we can't just stick to business as usual. We need to rethink all of our tools and how we use them to make sure they are fit for the new realities, and that includes also the tools of competition policy," end quote. I know you've said recently that competition policy will remain a side dish and not much will change, but nevertheless that seems to be quite a dramatic statement. What does it mean for merger control in your view? Are we looking at a relaxation? Are we looking at business as usual? Are we looking at something else?
Well, that's a very good question. Well, actually, the side dish issue is a slightly different issue. The question is competition enforcement central stage in being more competitive? And my point is that, of course, it's important, but competition policy actually magnified the impact of other, say, sectoral, for example, measures, if they're well calibrated. So it's an enabler across the board. So it's not the main, for example, well, let me take an example. There are many reasons why we don't have GAFAs in Europe, none of which is related to competition policy. We don't have enough engineers, we don't have a deep and liquid enough capital market, we don't have enough risk investment, name it. Our single market is incomplete, so unlike in the US, if you have a very promising startup, you cannot address at once the whole of the market. You need to go gradually, so that affects your profits, etc., etc., etc. And none of this has to do with competition policy. That was my point, because, of course, all those people that are making competition policy an excess of honor have another agenda. When you're saying, for example, that merger control is preventing Europe from having the world champions it deserves, this is factually wrong. We have reviewed since 1990 10,000 mergers. We have prohibited 39. And out of these 39, if you take out those in which the acquirer was a non-EU company, and therefore it couldn't have been an EU champion at the end, then you're down to 15. And if you subtract from these 15, those mergers for which the merger was giving rise to a kind of regional champion within Europe, in a couple of member states, then you're down to 7 out of 10,000. So, and if you review these 7, you see that there is no serious case in any of these 7 cases for having prevented a global champion. So what I meant to say is merger control is not the issue when it comes to competitiveness. Does that mean we should do nothing? No, because competition policy should adapt. Policy should adapt to 2 things, essentially. Market realities. They changed terribly quickly for the last 10, 15 years. And it should also adapt to the evolution of the global economic policy goals of any jurisdiction. Competition policy doesn't operate in a vacuum. Competition policy is not something that hangs completely independently for the rest of the policies developed by a government. So, to the extent we respect our core mandate, which is to allow markets to well function and promote competitive processes which, in the end of the day, favor competitiveness and consumers. To the extent we respect this core market, we should try to also help reaching the other political objectives in terms of economic results. For example, decarbonizing the production process. For example, being more competitive, et cetera, et cetera. So that's what I mean. I think it's important to explain it in a very concrete.
Yeah, that's a very clear exposition, and I think Commissioner Ribeiro uses that word, or has used that word herself, enabler.
Oh, it is an enabler.
Speech.
And so, to go to your questions, because I don't want to avoid your question.
Yeah.
We will review our merger guidelines, but we have also decided, and that was clear as a recommendation in the Draghi report, and we followed that recommendation, not to change our merger regulation, which means the law will remain the same. We will adapt the guidance. We will adapt the guidance for many reasons. The first reason is our current guidance dates back 20 years. And you know what? In the last 20 years, the world has changed quite a bit. So, for example, the whole of our merger policy in tech, the development of innovation theories of harm, how do you protect innovation in case of mergers and keep options open for innovators, none of this is in the current version of the guidelines. The second thing is Mrs. Ribeiro has decided to open the revision of the guidelines beyond what was mandated, which was the horizontal merger guidelines, onto also the non-horizontal merger guidelines. And so we will review both. And the reason why we will review both is that in this world of ecosystems, the distinction between what is horizontal is not horizontal is increasingly complicated to make. The two dimensions or the three dimensions, vertical, horizontal, conglomeral, are more and more intricate, and it's actually blurred the lines to keep it in two different set of guidelines as if it was completely independent. So we want to review both, and we consider the possibility to merge them into one single set of guidelines, as in the US with last year's merger guidelines. So you should expect that the new merger guidelines are more fit for purpose, and you should also expect that they answer the three questions that Mario Draghi asks. Mario Draghi called for an evolution and not a revolution, and I quote him. And the evolution, in his way, in his mind, should go on 3 points. The first point he makes is that, well, look, listen, Commission, you've been probably the best in the world over the last 20 years in devising innovation theories of harm, so protect innovators and the innovation process against abuses of dominant position or against mergers that increase market power or against cartel-like behavior. But the other side, the flip side of the coin, is what about agreements and mergers that actually allow an innovation to occur that wouldn't have occurred absent this merger or this agreement? And he has a point. And one of the reasons why we have not done much in this field is that there are very few academic work. So we need to sponsor a bit of work there in order to understand better what is at stake. And the second reason, to be fair, is we have very, very, very few, actually I think only one case in which this was presented as a defense by merging parties. So there is no experience. It's not that we have denied this defense, it's that it was simply not presented. But it is a fair point. The second point that Draghi makes is investment. And there, in essence, what the report says is that, well, in most cases, in most markets, size doesn't matter. Actually, talking of European champions, and if you define a champion as a company that is world leader in its market, then you'll see that 9 out of 10 of these champions are SMEs in Europe. You know, like this small Dutch company that is the only one in the world building the printers for this very, very small
ASML.
2 nano speed. Yeah, exactly, ASML. So we have many ASMLs, maybe not all that prominent and successful, but this type of company. So this creates zero problem on the merger control. They're small, and this is who we have. But in some markets, the markets in which there are high sunk cost, there are long cycles. Markets are worldwide. Take, for example, steel making. Well, their size matters, especially if you want to be a decarbonized steel maker. You have huge investments, and their size matters. So what Draghi says is, in these situations in which size matters, you should pay attention to whether a merger that otherwise creates competition issues allows for this investment to be done. Well, it wouldn't be the case otherwise. So we will have to review that question as well. It's a complicated question, of course. Our experience with this type of commitment, I promise I will invest, is not that great historically. We have accepted it twice, and twice the commitments were not fulfilled. But we need to review it. And the third issue, and we'll not elaborate because this one is even more complicated, he says you should look at resilience as well. And that is complicated for 2 reasons. The first reason is whenever resilience can be integrated in a competition analysis, very often it will run counter to what we usually accept as efficiencies. Take for example, a merger that would cut the cost of the logistic chain, which is very, very, very common. We take it as an efficiency that will drive the cost down. So even if they have more market power, their incentive will be to price lower. But at the same time, it will massively decrease their resilience, because if there is a problem, whatever, a war, a pandemic, even a volcano, or what have you, because you have no stock, what makes you effective in normal time makes you very vulnerable when you have this type of incident. How do you deal with this? And the second part of resilience is not even cannot even be integrated into a competition analysis. Geopolitical risk, for example. So this will be tricky, but these 3 issues we're committed to look at in the merger review.
That's very interesting. I think you ultimately referred to the word efficiencies. Mm-hmm. So as I understand it, these issues, innovation, investment, resilience, will be looked at largely in the context of, if you like, an efficiency type defense to what may otherwise be a potentially anti-competitive transaction.
Exactly.
That would be the analysis.
And more generally, I think part of the issue, and that goes for mergers, but that goes also for antitrust, is how do you integrate externalities, positive externalities, into an efficiency defense? And that leads to the issue of the potential complementarity between competition policy and, for example, promoting decarbonization.
Okay, I looked the competitiveness compass document, which followed the Draghi report and kind of sets out the Commission's take on that, if you like, refers to the guidelines looking to be more supportive of companies, quotes, scaling up in global markets. Would that be similar in your view to the investment point you were making, or is that a different point?
I think it's for a large part the same point, because the compass was written by people that were taking inspiration in the Draghi report, and these are the 3 points he make. Yeah. The limit, of course, is because the clear choice was made not to review or revise the merger regulation, which is the hard law there is a limit to what you can do. You cannot just be nice to companies to scale up if, say, it creates a monopoly. So whatever the creative interpretation of the law you can make, it would be contrary. The courts would not allow that. So there is a margin, as always in life, and certainly in competition policy, and even more in merger control, because you're talking about the future. So, there is a margin of uncertainty that is kind of embedded. But this margin is not infinite. And the second thing that is interesting, and I don't know what the review process will give on this, is that if you decide that you will be more sympathetic to firms scaling up, of course, under our statutes, you will be more sympathetic to any firm scaling up. European, Chinese, Americans, any firm that you need to review under your merger control regulation, wherever it is incorporated, we are bound by law and by the principles of fair trial to apply evenly our policy.
You referred, before we move off mergers, I think you referred to this case possibly in passing, but the Vodafone 3 transaction, which you'll be aware of, cleared by the UK CMA with an investment remedy. You said you found it difficult. You might find it difficult for the Commission to actually decide on those types of remedies. Do you have any particular comments on that case and its relevance?
I have two comments. First, a general one and the one that is centered on the case. Maybe I start by the comment centered on the case. The specificity of this case is that it is a case that happens in a heavily regulated environment with a sectoral regulator. And my understanding, I'm not the hawk specialist of this case, but my understanding is that the investment commitment is linked to the license to operate on the market, and that there would be some kind of automatic revocal of the license in case the commitment is not fulfilled. This is something you cannot do in any market. Actually, in very few markets can you do this. So this is clearly a specificity of this case. Now, the broader issue of whether you can accept a promise to invest or even an actual investment in return for more market power, in the end of the day means that you accept that you will finance these investments through a private tax on the consumers or the customers, if this is an industrial good. That is not a legal question, but that is a policy question. Do you want to do that? And so that is certainly a question we will need to look at and maybe answer in the process of the merger guidelines review. My second point is that there is a more general point in the case of the UK, which is that 6 months ago we were told by the UK that the worst evil was behavioral remedies, and 6 months later they accept a completely behavioral remedy that is a promise to invest. So in that respect, the European Union sits in the middle. We don't like too much behavioral remedies. We never did, not least because you need to monitor them. And that takes a lot of resources. But sometimes it's the only solution, and they effectively fix the issue you had. And in this case, we think we are compelled to accept them. So I hope the UK will stabilize somewhere in the middle of the spectrum as well.
As you know, it's undergoing a revision of its remedies process, and it seems likely to certainly move in that direction.
Yes.
Let's move on to general antitrust. You've made some specific references already, but what is your view on what more generally, what the rethink referred to by Commissioner Rivera means in this area, and in particular if we look at climate change cooperation? I know that the Draghi report suggested, amongst other things, clear guidance and templates and a simple streamlined process for coordination, including in relation to decarbonization and other issues. So how do you see that in practice working?
Okay. Well, we to be fair, we have rethought already most of our rules over the last 5 years. But there's still a bit of work to be done. I think the main field is a field that interests remotely an international audience, and that is the control of state aids, which is a small European idiosyncrasy. We feel passionately about it, but we are the only ones in the world, so maybe I will not bother you too long with this. But this is how you ensure that the state subsidies that are given in the field of decarbonization of industrial processes in particular, which will both allow us to be more autonomous than relating on fossil fuels that we do not extract on our soil, and be more competitive and be decarbonized, which is good for everybody, it's a common good. So how this can be given more effectively, more in a more targeted way, meaning not fragmented too much our internal market, and at the same time having a high leverage effect on the rest of the economy and competitiveness. This is what we're trying to do. You know that Mrs. Rivera was in charge of something that we call the Clean Industrial Deal, which was adopted a few weeks ago by the college. And alongside this Clean Industrial Deal will come a Clean Industrial Deal stated framework, which will provide for a number of simplifications so that we can deploy more effectively in a more targeted way and more quickly the necessary public means when we want something that doesn't make sense on purely private terms to happen nonetheless, because we think it's desirable because of the beneficial externalities. So that is one thing, but I don't drag too much on this. The second thing is indeed merger control. We talked about it. Merger control, if you think about positive externalities, is probably the most difficult thing. And I don't think anybody suggests that to go to the extreme, a lower monopoly because it's good for the reduction of greenhouse gases. And most of the time, actually, there are many other ways to reduce the production of gases that do not involve creating a monopoly. So the focus here is really on traditional antitrust. So how do you interpret the provisions in Article 101, Paragraph 3, and also I would say the concept of objective justifications in Article 102 in a way that both make sense from a competition point of view and allows for cooperation or practices or unilateral practices that are desirable from an environmental point of view to happen. So that's the issue. We have started to review this issue in our horizontal guidelines, and I think I talked about that last year, so I will not reiterate. So we said, well, if basically the only way to achieve a reduction of sizable reduction of greenhouse gases is that you cooperate, and that entails some restriction of competition, come and see us, and we will see how we can minimize the restriction and to keep the same results in terms of beneficial environmental results, and we will provide you some form of antitrust immunity or a comfort letter. That didn't work that well. That didn't work that well for several reasons. Well, that worked relatively well at member state level. So some member states have some cases of that case, and they bless actually cooperations. That didn't work at EU level, in my view, mainly because the US has a completely different view. And typically the type of agreement that we would have to review at EU level are agreements that have a large footprint. And even if we issue a no action letter for the EU, if there is a credible risk to be prosecuted in the US, well, they would simply not do it. And this is what happened to this project by banks. This is what happened to this project by insurances. They simply decided to drop it. while we had signaled a willingness to provide antitrust relief.
That's a very interesting issue. So yes, as you say, regulators like the Dutch regulator have been producing guidance fairly regularly, I think, on particular cases.
Yeah.
We're not seeing so much from the Commission, but you see that as the really key issue, that other worldwide regulators are not taking the same approach. And banks, for example, you were willing to give something and they couldn't get comfortable elsewhere.
No. And, it's like in cartels. I mean, nobody will come for immunity in the EU if you think you will be prosecuted in the US, or the other way around. So if you do not have an alignment among the two biggest jurisdictions in the world for these large international agreements, you're sunk. Nothing happens. The one cannot move without the other.
Do you see any prospect of that changing in the future?
In the specific area of benefits to environment, I think that the prospect is relatively low. I don't think the Trump administration has given clear signs that this is the direction they want to go to. But more generally, on the concept that a number of things do not happen if we do not cooperate, I think there is 100% alignment between this administration and the Commission. We have met both Gail Slater and Andrew Ferguson yesterday with Mrs. Ribera. And it is clear that both sides have an understanding that a deep cooperation is indispensable and a willingness to make it happen.
Okay. While we're talking on US EU relations, I'd be interested in your thoughts on President Trump's comments, not least in the famous executive order from February 2025 and other comments about EU regulation amounting effectively to a tariff or taxation regime. How is this being taken into account, if at all? How is it going to impact the Commission's viewpoint and approach across the range of its agenda?
Well, I have to confess I don't really understand what the President is talking about, which leads me to believe that I think it's a misconception or a misunderstanding. The only thing that he could label, although that would be wrong, as a tariff or a tax are the fines we put in antitrust. But it seems it's not what he's referring to, because this administration goes quite strong on ex post enforcement of competition rules, in particular in big tech, which is very welcomed. So I guess they have no problem with others doing the same. So that leaves us with the DMA, I suppose. But it happens that in the DMA field, we never have imposed any fine. So what is this tariff or tax is relatively mysterious to me. So which is why I think it is, in the end of the day, a misconception, unless he refers to a few national digital services tax in certain member states.
I mean, as you say, the US is taking their own enforcement action, but maybe it's something that is happy for the US authorities to do, but not for the EU or other authorities to do. And we can attack our own companies, but not someone else can't think.
You know, the issue in antitrust is not so much companies than behaviors and impact. So if this theory that you can only attack your own company were true, I guess the US government would never have fined European banks for having, in their view, not respected their embargo on trading with certain countries. Because, I mean, there were European banks on European soil. So the reason why they did that is because what you care about is not so much where these companies are incorporated, is where the behavior produces effects. And what we say very simply is, and I think on this we have a clear identity of view with Mr. Trump is that sovereignty means that companies, wherever they are incorporated, when they have decided to be active in your jurisdiction, they respect the rules of that jurisdiction.
Yes, I think that's a pretty clear comment that this, if you like, noise and bluster about tariffs and the activities under the DMA is not going to have any impact on future Commission activity.
Of course not. I mean, there are two different things. Whatever you think about the politics of the US administration on tariffs, this is their God-given right. They put tariffs. The others, like the EU, will decide what they do. They retaliate, they don't retaliate, they negotiate. But you're sovereign, so if you decide this is the best interest of your people, you do it. And maybe others do not like it, but there's nothing wrong, intrinsically about this. When it is about identifying this with the way others regulate activity on their soil, that's different. Because it's not any longer your sovereignty, it's invading the sovereignty of the others. This is where I think we have an issue. And indeed, we have a parliament that is just as sovereign as the Congress is, that decided that these are the laws that we need to have for the benefit of European citizens and businesses.
And also potentially US
I was about
as
to
well.
just to say that. I mean, I was interested yesterday to hear Mr. Sweeney from Epic Games explaining how much the DMA was providing American firms with opportunities to compete against companies that were using their dominant power in order to try to prevent that. So, but the bottom line is we don't do it either for the benefit of American competitors. We do it because we want to have competition in Europe.
Yeah, it's agnostic as to the who it benefits. I think you're saying, so you've mentioned several times the DMA, the Digital Markets Act, now in force for and operating for a couple of years. I think you mentioned there have been no actual fines, although we expect possibly some fairly soon. What do you see as the main achievements so far under the DMA?
Well, I think twofold. First, they restored choices for consumers for a number of services, like, for example, the possibility to download applications outside of app stores, and a number of other benefits. I mean, not having a default browser whenever you buy a device, and a number of other things. And the second thing is, and that was the second main objective of the DMA actually, it opens possibilities to compete for smaller firms that may be more innovative, but that so far were preventing from having this opportunity because the bigger guys could deploy strategies that would actually cut them off. So I think so far we will publish in just a few days a first outlook of what we see as the benefits of 1 year of enforcement of the DMA. And I think they're quite sizable. Now, we never thought on March 6, 2024, the world will change all of a sudden and the DMA will make immediate changes. It has never been conceived to achieve that. So the biggest change, in my view, will come over time. And in the areas which we are currently litigating, because of course, where the gatekeepers do not comply is where the provisions of the DMA hit them at the heart of their business model, where they derive their extravagant profits from. Like, for example, the App Store. Like, for example, targeted advertisement for Meta. And these are things very often that we have already, at least on the principle, challenged under antitrust. We have put huge fines and it never stopped. And that's one of the reasons why we have the DMAs. We thought, okay, well, if whatever the fines, they reiterate the infringement, well, let ban it outright for these very dominant companies. And so they fight tooth and nail, but when the dust will settle, in the end of the day, they will have to comply one way or the other. And then new benefits of the applications of the DMA will materialize and new opportunities for competition.
Do you see anything that you would have liked to have done differently when the DMA was put in place? Are there any issues in terms of how it's actually operated from your point of view?
Well, the main issue is that the resources we were promised to enforce it never came. And that forces us to make choices where you shouldn't. For example, we chose to focus on making the DMA under the current perimeter work. So for the core platform services that have been identified, the 1024, and for the gatekeepers that have been designated. So we didn't go into the area of designated new platforms or gatekeepers, while there would be a case at least to think about what we do, for example, in cloud computing. We don't do that because we focus all of our resources on making work what exists today rather than trying to enlarge it and not being able to effectively enforce. So that's a limitation. That is undesirable, but that's the way it is.
All enforcers have limitations, of course, don't they? And I remember you making this exact point, I think, last time we spoke here. Finally, on substantive points, I'd be interested in your comments on what you're doing in generative AI and AI products. I know there was a joint statement in July 2024, Commission, CMA, DOJ, FTC. Obviously, some of the individuals have changed. There was a Commission policy brief, September 2024, which looked at similar issues. So just interested in your comments, please, on what the Commission is focusing on here and its key concerns.
All right. Well, when AI can be the best or the worst of all things. So the first thing we're monitoring how is competition taking place in the area of the multitude of young tech that try to develop generative AI foundational models. There are around 300 in the world who have the necessary resources to be able to make breakthrough and successfully reach the commercial stage. And I mean, DeepSeek, Mistral AI is just the most well-known of this, but there are many, many, many others. So this is an environment in which the competition is vibrant, and we do not have any specific issue, but we monitor. Secondly, the second question is, are we in presence of this kind of platform type thing in which market may tip, and when they will have tipped, the winner will take it all? That's the second reason why we monitor them very closely. And what we see so far doesn't suggest it. It's a bit early to be completely definitive, but what we see is that competitors that work with open source models, if you're smart enough and you find innovative way to build your algorithms, you may end up training your AI for a fraction of the cost and be at least as effective as the much more costly ones. So that is really interesting, and that means there is a real competition also at the level of the efficiencies and the innovation and all of this. And we have no reason to believe at the moment that this competition is impeded. Thirdly, it could be impeded in which situation? It could be impeded if one of the players that control either one or several of the key input into AI would have some stake in the game into preventing the others to have access to it. And for this reason, we are monitoring very, very closely the relationship between the gatekeepers already identified, So Microsoft, Apple, etc., etc. And the most promising of this young tech active in AI, because as I said, AI can be the best of the worlds. I mean, take the example of browsers. I mean, if it is not a tipping market, if the winner doesn't take it all, then AI will certainly be the most effective way for competitors to challenge the dominant position of Google in the search engine market. Now, if this is the other way around, this is a tipping market, the winner takes it all, and Google manages to secure the winner, then it can fossilize its dominant position forever. Nobody knows for the time being what will be the outcome. Which is why we monitor the relationships between Google, Amazon for the cloud, Microsoft, name it, Apple, and these young techs in order to see what happens. For the time being, we don't have any reason to launch an investigation, and even less to attract this under the DMA, because there is no platform issue. So that's the way we do it. And lastly, we also look downstream, because it's not only companies that have some degree of control on the inputs, but it's also the distribution channels. And then we pay specific attention when the same company controls part of the inputs and part of the distribution channels, or actually a great deal of the distribution channels, which is, for example, the case of Microsoft. And it's the reason why we have had a really close look at what they have been doing, both in the relationships to OpenAI and in their taking over of all of the staff of, I think it was Inflection.
Okay, well, that's a very clear exposition. You're looking at, as I understand it, the upstream and downstream foreclosure type issues, if you like, with the young tech squeezed in the middle. Mm-hmm. So data, chips, computing power, cloud, expertise at the top, and the distribution channels at the end, and whether there's going to foreclosure at either level.
Indeed.
Okay, well, that's extremely interesting. Thank you very much, DG Guersent. So just to finish here, you have been the DG of DG Comp, I think, since January 2020, and will leave, and in fact, leave the Commission, European Commission, later this year, 2025. Looking back over your period at DG Comp, what do you think was the most impactful or important case or other success that you dealt with during that period?
I think the most impactful case was not a success, and this is the loss of the Article 22 case in Illumina. Because the world is changing, because innovation defines more than ever in history competition relationships, it is really important to be able to review this acquisition of nascent technologies by companies enjoying market power, whether it is to kill it or whether it is to cement their paramount dominant position or any other type of anti-competitive behavior. It's really a question of global general interest to be able to do this. And unfortunately, the loss of the Illumina Grail case in the European Court of Justice leaves us with few possibilities to do this. So we are trying to do this through the member states. I think we will be successful. It will be longer, it will be more imperfect, it will be more complicated. So I'm afraid the most defining case of my tenure is not a success, unfortunately.
Well, that's very interesting to hear that. And as you say, it's become a bit of a messy situation with reliance on member state call-in powers, and in fact, whether that's a valid approach also being looked at the moment.
Yeah, well, I'm a lot more confident for this. I mean, I think it would be very difficult, in particular for a European court, to dispute what a member state does under national law. So I might be wrong, but although I'm quite imaginative, I am not imaginative enough to see by which legal mechanism that could happen. So I'm relatively confident.
Okay, that's good. And finally, or one or two final questions, very briefly, if you don't mind. What one piece of advice will you be giving your successor in your role?
Don't crash the Rolls-Royce. That's the piece of advice that Director-General of Competition give to the next one ever since Philip Lowe in the early 2000s. DG Comp is one of the best, in my view, the best competition enforcement agency in the world. And there are a number of reasons which have to do with its corporate culture, its DNA, if you wish, which is that we empower people. In DG Comp, if you are a young investigator, you know your case better than anybody else, you're smart, you're hardworking, and you devise a perfect and robust theory of harm, you have the power. And that's the reason why they stay with us rather than, earning 10 to 50 times more in the private sector. It's because they matter. And that means that you need to have a certain degree of humility in the management. And the higher you go in the management, in the hierarchy of DG Comp, the more it is desirable that this degree of humility exists. And so that would be my piece of advice to my successor. You don't need to be a genius in competition law. I'm not. I'm certainly not. You don't need to be to have any other skills, but to empower your colleagues, to put them in the best position to deliver what they do best, which is delivering very difficult cases where we have 1 against 10 because we have far more scarce resources than the opposition.
And finally, what will you miss most?
Oh, God, all my colleagues, the thrill, the intellectual challenge, name it. I have decided to retire. I didn't have to. I could have worked 5 more years. But I'm working for 40 years. So I decided it's time to go. Also, it's 5 years I'm Director-General of DG Comp. And I'm a great believer that after some time, yes, of course, you do your job well. And I think I managed decently well DG Comp. But what I had to bring as a new impetus, I have brought. And it's time for somebody else to put his touch while preserving the DNA, as I said. So I will miss all of this. At the same time, I'm extremely happy to be able to, depending on whether you're American or English, grow my tomatoes or my tomatoes in Southwest France.
Well, your many admirers in the competition community wish you a good retirement. Thank you very much for appearing on Our Curious Amalgam, and hope you enjoyed the rest of your time at the spring meeting.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.